legal advice for an individual legal situation, or implored for making a legal decision, you will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Saturday, February 19th, 2011 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. We're going to go to Q&A and see if anybody has any questions. So press star 6 followed by 1 if you have a question to get in a queue line. Star 6 followed by 1 once we start.
Q&A session started.
Okay, anybody have a question? Star 6 followed by 1.
Hey, Christian, how are you?
Hey, Darren, how are you?
Good. Several questions that I have, and I guess it's just a matter of, I'm back on the indenture, just on perfecting it. And I had a question in regards to, and I know I asked you this before, and I just wanted to double check, but on the indenture, especially when we're going, if it's a matter where we're going to extinguish the debt, we do send a copy to the IRS as well as the trustee, since the IRS are the accountants.
Yeah, I would inform them what was done, yes. Uh-huh.
Now, is there a specific department within the IRS that we're giving notice to?
The private side of the IRS, which is Ogden.
Private side. Okay, private side. Okay. Do you know if that department has a name at all, or?
No, I
anything?
don't.
Okay. Whereas it isn't like a trust department or something like that, because I'm sure there's multiple departments.
Yeah, but I think that whole location, it seems like anybody gets something out of Ogden, that seems to be the private side, so.
Oh, I see. So it should include some type of Social Security identification number to it.
Yeah,
that's really
it was talking about they had a normal communications through like West Virginia or Covington or wherever it was, but then they got a letter from Ogden.
Sure.
And then there was another fellow that he sent his stuff out from some other location, like in Carolina or somewhere, and then it ended up in Ogden. So Ogden seems to be the private side of the IRS. Now, I don't know if it's, you need a specific person or a department. That I don't know.
So it would probably be best to put like a brief cover letter on it to whom it may concern. Not exactly sure of which specific department.
Yeah, because
it's just to give you notification.
Once they were doing some kind of privateness on the public side sent it to Ogden, and then somebody from Ogden responded back, and now they got themselves a contact.
I see. Okay. Yeah, because I'm just curious about that. All right, so we'll look up the Ogden. That's Ogden, Utah, right?
Yeah. Mm-hmm.
Yeah, because I know a lot of times is specifically when you're dealing with them, they'll go by your zip code because it's based on at a regional offices, like from Florida to Atlanta. But to get something from there, it has to constitute something totally different.
Right. So.
Yeah, but of course, they're not going to spell it out or make it clear why it's coming from that location, because a lot of the letters that people are receiving from those areas are just computer generated.
Yeah, that's okay. There's still supposedly a computer name on there.
Sure. Right. It's on the all caps name. which also leads to another question. I just have two questions. Can you actually do, through an indenture, put like a copyright on that all caps name as your commercial name and name it as the trustee?
Yeah, but how's it going to do anything?
Well,
Isn't
so
a copyright commercial, and isn't that DC?
Well, from the standpoint, if you're claiming it as trust res and someone uses it, then they're breaching your trust. Can that be?
But I don't need to have a copyright on that. I mean, like I could say they're using my property anyway, so.
Right, but you want to make a record of it because everything's about record.
Yeah, but my sticking point is that I'm making a record of a public transaction, so I don't want to do a copyright. I don't believe that. I don't think that's private. I think that's public.
Oh, I see. But so you don't want to make it like trust res.
Yeah, I think it's more like doing.
I see. So if you're going to do it, just make a public record of it, whether it's a UCC or county records or both, and this way you have two witnesses.
Yeah, I think it's more important that I just claim it all. If I claim the title anyway, I wouldn't need to go and copyright it and do another public act that's unnecessary.
Okay. Now, and when we're saying claiming it, here was a question also I asked you last week, and we talked about was even when we're even creating our trust, where we were talking about, well, we name the trustee as the President of the United States of America, which is on the private side and not on the other side where he's the Commander-in-Chief. Wouldn't you actually make it President pursuant to your date of birth? So then this way you can say, well, that was when the trust was my intent and purpose when it was created. Was at my birth?
Yeah, true. But then since then, there's been many presidents, and the current president's the one in charge. So I'm trying to do things now. So.
Well, in other words, take for example, I created an indenture for a state agency. But in the meantime, after I already created my UCCs, they had a changing of the guard, let's say, or a different election. Now we have different ones, so then what I had to do was go back and reformulate my indenture because I didn't send it out yet, which was okay. And I think I just put the additional verbiage saying John Doe and then formerly Jane Doe, previous trustee, and to all successors. So in this way it goes from that beginning stage clear to anybody that comes into office is assuming that trustee position, especially through that office, but not naming the office because I got to have a live human person in there.
Yeah, you can do that. Yeah.
Okay. Yeah, just including on that one. And another thing also, speaking where we're getting into date of birth, on the Declaration of Independence, as we're claiming that, is that on the allonge, shouldn't we actually, since we have to make a claim of our unalienable rights endowed by our Creator, shouldn't we use the language, especially by the date and time of our birth and nativity? So saying is that that's when my rights went into effect, was the moment I was born. That's when my unalienable rights went into effect. So this way they can never come back and say, well, you're claiming it now, but this was an action that happened before, so all you had was legal rights back then. You didn't have an unalienable right.
Yeah, it's ab initio, yeah.
Right, or what? Yeah, right, ab initio, or a non-proton, I guess you could say. But I thought, and I sent a copy of that to your wife to see how she liked the verbiage on it, and I talked to someone else about it, just on the allonge, and it was just nice to expand the definition. And this way, it's just a way that we're covering all our bases in the different things. That's why I was also asking is on that Sestacute Trust, why not name the president when you were born, and then just add the verbiage to all successors thereafter, or, as you say, ab initio. So this way it's covering it from the moment of birth, because you don't want to use the moment of conception, because then they might say Roe v. Wade in there. Just thoughts, just some thoughts to kind of perfect what's going on.
Yeah, that'll work.
You think that'll work? Okay, so you're saying don't copyright the name and put it in that. That's going to fall under where you're claiming the straw man on just your own on your own indenture.
Yeah, I'm just privately claiming it and then giving the public notice of that. But yet on the notice, nobody's going to know what I claimed. But I've claimed it publicly, so.
Okay. Because I remember I heard even Gene Keating's talking about that. I know he's on the DC side. It was something about, but you can only do a UCC in the state in which you were born with. But I didn't catch all of it. Where people do common law copyright.
Yeah, but we're not using it to attach where the property is, because we're just using it as a public notice.
Right. Yeah. Mm-hmm.
It's not like we have to do it in the county where you were born, because that's where your property is and it's attached into through the thing. No, we're not attaching anything. We're claiming it. We're moving the title.
Kind of answers it, because I was going to be sure. I wrote down my questions. Okay, so we don't need to do the copyright, but the allonge, expand the definitions of the allonge, including the date of birth, which is good, because this way you have to make the claim of the right. That's just like in that PA case I sent you from 1790. Judges don't recognize unless you make the claim. And then you have a record of the claim. So that kind of covers the bases there. And the other thing is just...
you manifested your intent by doing some kind of action. Well, you publicly gave notice. You claimed it. That way it can't go abandoned.
Okay. Just one other question. I'm actually creating an indenture, hypothetically, of course, based on a contract that it was based on a performance that an employer was to pay so much for a particular position. And basically what happened, we got into an argument when it came back to the said judge, you got to give your SS number for tax purposes. I said, no, you don't. That's not a requirement of law. That's under EECO versus Taco Bell. You could read the case. Also, the Social Security Department clearly states that. And because of that, they terminated the position. So I thought, just for giggles, I might go back and say, listen, since we did have a signed contract, and I'm going back and take it in the side of equity, because now I'm talking about a duty and performance in regards to what was stipulated on the duties and the performance, that they were going to compensate me so much, is to go back after that and send them an indenture for that lost compensation. I thought that would be a good equity case to try to take that in at, since there was a contract in force.
Yeah, I suppose.
What do you think?
The thing about the contracts are they're for money, then they're for DC, and if they're for performance or something else, then they could be considered private contracts. So I wouldn't want to commingle and use a public contract.
No, but I'm just saying here is what I could do is just take it to basically send him the indenture and saying, okay, here's the indenture.
But it's like you don't want to try to fight the leaves of the tree, because there's too many leaves. I'll waste all my time trying to fight all. I really don't do that when I can pull the whole thing out by one root. So.
Okay, explain it. What do you mean? I mean, just to go through. We still got to go through the process.
So many things that are going to happen in life that are just little individual cases, so to speak, but they're like the leaves of the tree. They're never ending, because I'll spend all my life trying to fight the leaves when I could have done it much more simply and just pulled the whole trunk out and got the whole tree and all the leaves. So all in one fell swoop. So.
Well, I'm just looking at it as though it would be, just something to partake in, and also to get, sometimes you got to get your feet wet in certain cases, especially as we're learning the equity process.
Yeah, well, you got your battles, which one you want to choose, or else you'll be fighting a lifetime of battles that, I ain't got no other time to do anything else, so.
I understand. But, I look at it this way. If that indenture is worded correctly and properly, is that really, and your paperwork is done properly and correctly, I don't see where it can actually be a long, drawn-out process.
I don't know.
I mean, it's not, on the ad law side, they can drag out for years. But I don't really see that on the equity side as much, because really the argument is not going to be there once you got them on the breach. Because really, the only argument is that they're going to have to prove is that they didn't breach it.
Yeah, well, we need some people with some litigation skills that can take the equity things in and try that, so we can get the enforcement perfected. That's the more important thing, I think.
And that's what I think. I mean, I'd like to experiment with a few cases. Once we have the groundwork done, I'll be more than happy to take it in.
Yeah, because I'm going to do some tweaking on different things that what we thought and were different, and we're going to have to do things different than what we planned. So let's start out with.
Yeah, I'll be the first to volunteer. I'll go in. I'll go in, and I got a few small cases, which to me are no big deal. Like it doesn't really matter. But I would like to go in just to kind of like experiment to kind of get your feet wet, And it's kind of like if you have like a boxer, he's going to start out with the real easy fight to begin his career. But of course, as he gets a little bit more seasoned, a little bit more experience, he's getting tougher fighters as he's going up the ladder.
Mm-hmm.
I look at it in the same kind of challenge,
Right.
I want to take something in that's real easy, whether I get shot down or not, but at least I'm going to go, okay, I should have done that. Like, I want to do it not on really big cases, because in my opinion, if I have big cases, the biggest thing is that I get them on a breach through the indenture, and I can bring that action in at any time later on. So if I have a few little ones that I can play with and get the experience and knowing how the court's going to react and go, okay, I got a good feel of it here, then as I get seasoned, then I can bring in the bigger cases and go, now I know what to expect.
Right.
Okay.
So I'd say
Sounds good to me.
The book is the biggest thing for finalizing what we're trying to do.
The what?
The Gibson book is the equity chancery courts. The Gibson.
Right. That's such a great book. That is such a great book. Whoever was the guy who found it, that's kudos to you. That was a great find. That was like a diamond in the rough there.
Yeah, that's an outstanding book amongst all the others.
Okay. And it was funny. I was chatting with the missus today, and we were talking about. Because I'm like I said, I've seen some other groups out there, and like there was a case, there was a cop from Sarasota, Florida. He got fired from his position because he tried to expatriate himself, and he tried to claim himself as a sovereign citizen. Well, they had some paperwork that actually you could download online through the paper because they wrote up a story on it. And I said, well, his first mistake was just the term itself. A sovereign citizen is really an oxymoron. It's like calling yourself a free slave.
Mm-hmm. Yeah, he wants to be He wants to be on the private side, but do a public job, huh?
Well, the thing is that he claimed if you saw some of he tried to claim to be the grantor, the grantee, and the secured party creditor. So he breached his own trust right off the bat with that law terms and equity terms, and basically his paperwork conflicted itself or contradicted itself, and he just didn't create proper records. I think he could have done it because of what he was trying to do, but I think his intent was good, but he didn't do it properly. But yet again, too, they cannot saying, well, you got to be a U.S. citizen. And you can't expatriate, which is totally false. It also talks about expatriation, that you have a right to do that. Even Congress acknowledged that, whether that's a statutory right or whatever, but you still have a right to want to. That's at your own discretion. But even the term U.S. citizen is an oxymoron in itself, because that's a fictional law which was ruled on in 1855 in the California Supreme Court in Ex Parte Frank Knoll. And I think that plays a big part. But it was interesting to see what this guy was doing. And it's amazing. A year ago, I wouldn't have really recognized it, but now when I look at it, I look at it in trust eyes, and right away I'm seeing, he breached his own trust. There was just like on that video that I saw last week, and I sent everybody a copy of, is what the guy was doing in court. And he was trying to name the judge as trustee, and she ordered a psych eval on him. I said, and everybody's going, the crooked judge. And I said, no, you don't understand. The court acted properly. He commingled his own trust, and that's why she ordered the psych eval on him.
Right.
The court acted properly.
Yeah.
So, but it's funny now, and I just step back and I look at it, I'm saying, boy, I see things so much clearer through, looking at things in trust eyes,
like putting on spectacles that corrected your deficient vision, and you never knew you weren't seeing properly, but now you can see clearly.
That short-sightedness, isn't that what Bovevere says? That short-sightedness?
Yeah.
Yeah. Okay, that was my only question. I had a few questions, and you answered all of them, and that's it. And I'll step off.
Okay.
All right, thanks.
Thanks, Darren. Tony, you're unmuted.
Okay. What I wanted to do is I have a couple of questions. One that just brought up the gentleman that was just talking about putting in documents to the court, and that the gentleman may have breached trust. I'm kind of wondering how are the different ways that someone can breach a trust or breach their own trust inside the documentation. What might be a few examples of that? And then a follow-up also, I was wondering if you could give me 3 of the first 12 courses that are recordings that you were recommending the other night that people listen to in order to get familiar with the approach that is being touted here. So I was hoping you could just outline maybe 3 of those, and then I could get started on them.
Yeah, if you would Skype Faith to Trust, that's F-A-I-T-H, and the number 2 and Trust. Skype her, and she'll give you the list.
Okay.
So the first question, how would you breach your own trust? Are you pertaining to say the indenture or a case, in court?
Well, given the example that the gentleman just gave, which was that the police officer, was using both trust terms and, I guess, debtor-creditor terms.
That was in court, or yeah. Because you probably couldn't breach your own trust writing your indenture unless you put some kind of private stuff in or public stuff in there. So I guess you could. But the whole point is you don't want to mix private side material with public side material. And I suppose that's part of the sticking point of most people, because they can't distinguish what's the difference between private and public. That's probably their hardest part. And everybody treats everything as all the same. It's not. So
what are some examples of things that are private and public?
Well, anything that is commercial in nature is public. Anything that involves UCC Article 3, 8, and 9, or anything in UCC period, Article 2 contracts. Anything that's done for money, commerce. And that's what the public side is all about, commerce. So anything that does anything with checks, bills, notes, bills of exchanges, promissory notes, money orders, anything that creates a negotiable debt instrument under Article 3, Article 8 and 9, contracts, Article 2, anything that's pertaining to that is DC, and it's debtor-creditor, it's public, and if you take your private stuff, merging of the titles, and you commingle it with that realm, you just breach your own trust.
And so what are some examples of private?
Well, if I take what I did in the private, merge titles, my records, and I put those records in the public realm in some way, so that they would be specifically identifiable and everybody would know the details, then I just breached my own trust. In fact, even if I was in the public side of the court and I wanted to come in and start talking about my private nature, or I got a private trust, you're commingling right off the bat. Or if you want to bring in the information that I'm a private citizen, or I'm a sovereign, that kind of stuff right in the court, that raises red flags automatically, and that's when they say you need a psych evaluation, because that's a shot across the bow telling you to shut up, because we don't want to hear that stuff here. You're breaching the trust. So all that private nature stuff that we like to talk about and tell these courts about, we can't do that. We need to keep a silent, tight mouth about that.
Is my name private, or is, I guess, what I think my name private?
Well, I think that's one of those line things, because you're seen in the public as so-and-so, but then you still got the same name in the private, so.
Say that there was a case where
It
in the
depends on what you put your name on, because I can do a private contract with that name, and now I can't put that in the public. But I can do a public contract, and I can't put that in the private. So the name can be either or, but it's what I use the name for. So I think that's the hardest part for people to understand, is what is public and what is private. And it's not that hard. It's anything that creates a negotiable instrument, a debt instrument, because everything in the public is debt instruments. You either sign your name to a contract that's for currency, money, so-called money, or negotiable debt instruments, credit, in other words.
So say that a document is drafted that's submitted to someone in the court, and by that I mean, say, the opposing attorney, okay? And in that document, there is a paragraph that says, hereby comes John Doe, upper lowercase, comma, grantor, pursuant to Doe, John, or Joe, was it Doe? See, Doe, John, whatever, his middle name, all in uppercase. By in doing that, and acknowledging both a private relationship, i.e. grantor, and then a fiction in the same document, could that be construed as a breach?
It depends on what side of the court you're in. If you're on the public side of the court, I don't care what name you come in with. They're going to look at it as it sounds like the same, and they're all going to treat it as a fiction name, period. I don't think that's going to get you under a breach because they're not going to treat it as a breach. Because they're going to construe it that one upper-lower case name is the same as that upper-case name. Because that's the only thing they're going to look at. That's the only thing they're going to see. They're going to construe it to be all the same, uppercase, fiction. That's on the public side of the court. Now, if I was in equity properly, then I could bring anything into the private side of the court under equity of my private nature stuff and talk about that freely in open court because that court is equity.
You said open court. I thought that I heard...
You did. On your past, we were thinking, okay, there was only just one court, and we had to go in chambers to get equity, which was the private side. Since that, which was brought out in the Hutchinson versus Maxi Center case, 1988 case out of Florida, that plainly said there's one court today that because the processes have been merged into one court, but there's one judge with two hats. And the two hats he wears is, one, he puts on the hat for the equity side of the court, which is the private side, and it's the whole thing done in the private side. And the other hat is the legal side, the at-law side. So one judge administering two different venues, two different jurisdictions, two different law forms, because equity runs under a different law form. It doesn't apply to statutes and codes. That's all at law. Equity runs under the maxims, principles, and how you invoke that. So it wasn't one form that we had to get in chambers, and that's where equity was. No, this whole side of equity is all equitable. It's all private. And the thing is now, it's just like two streams or two hats, two separate streams. One court, two separate streams. Two different venues, two different jurisdictions. Same judge wears two different hats. You just got to make him put the right hat on. And you do that by the paperwork and what you put in the paperwork. You got to invoke the court of equity by the wording and the pleading.
And so what you're suggesting is that it has been uncovered that really to invoke a court of equity, you enter what would be a pleading, regardless of in the normal, I guess, mode of the court, if you will, the normal filing procedures of the court.
Yes.
And that it's through the content of that pleading that determines whether or not we're invoking equity or at law.
Correct. There's certain switches that you have to put in there or certain verbiage that invokes a court of equity. And certain things you have to do, like not to claim damages is one. Not to have a jury trial. Certain things that you can't ask for over there because the damage is not equitable. Although a court can give you damages, a court of equity can give you damages if it wants to decide to make you whole in that respect. So, but we want to just go for the performance on the breach of the contract or the breach of the indenture.
This is my final question, and we can move on. I wonder if when a judge is speaking at the at-law side and says a comment such as, don't file any more papers, please. Is it possible that the judge might be wearing two hats, or is it just that they're saying, don't file anything more here at law?
Well, he could be saying that. Yeah, he could be saying that. Just don't file anything more at law.
Okay, well, hey, thank you, Christian. Appreciate it.
The equitable side is very simple. It only runs on less than 20 maxims. The statutes and code side runs on 63 million statutes and codes.
Where can I find the maxims for the equity side?
Just do a Google Books search for some of these old equity books. Put in equity, book or under Google Books. A lot of them in there in the index. They got tons of maxims in their explanations.
So max of equity.
Yeah, just 20 of them. Less than 20. Get the Gibson book we're talking about here. It's got maxims in it.
Yeah, I'm pretty sure that I have a link for that. If not, I'll ask one of the Skype members to forward that. But I'll get a copy of that.
If you want to know how to get in the Court of Equity, read that book.
Alrighty.
Have faith to trust.
Appreciate it a lot again.
Have faith to trust. She'll give you a list.
Great. Thank you.
Thanks for coming on. Dan, you're unmuted.
Hey, good evening, CW.
Hi. How you doing?
Not too bad tonight. Been NTTing all day long, so hypothetically, I'm going to be sending off some information to the IRS about breach of trust going for enforcement. In the meantime, there are currently no actions in any court about the case that I'm working on. And since in the past I've mentioned it before, so I'll do it again. Speaking of my truck.
Well, that's good because there's no additional accounts formed because that case
Right.
new account.
Right. Okay. Now, in the past, I've heard you say, well, let me get to that question in a second. Here's my plan. I'm going to start a case in the courts down here, but I'm from the very first moment, I'm going to invoke a court of equity. I'm going to go down, I'm going to start the suit, and then toss in a bill. When we start the suit, I'm pretty sure I've heard you say in the past you need to bond the case, and to bond it for just $1. Is that correct?
Well, the trust is the bond. So if you have a trust already, that's all you need because that bonds the case itself.
Really? Okay. Can you elaborate on that a little bit? Because I'm not connecting the dots there.
Well, we're all accustomed to seeing on the debtor-creditor side a bond drawn against the accounts. Really, the account is the bond. I don't need a bond to put in there. It's just like a barred card license.
Okay.
They just put the number of the account, the barred card license down.
Oh, gotcha. Okay. So there's no need to put the bond down.
The trust
now,
is the bond.
say that again. My phone broke up.
The trust is the bond.
Right.
Just put the number of the trust down, or the name and the number of the trust down. That is the bond.
Okay. The unique identifier for the actual trust will be the bond number.
Just like the attorneys put the barred card number down under their name.
Very good. Now, when I toss in the bill of equity, I'm going to, inside that, for the original bill, I'm going to use it for discovery as well. I should probably put, is it possible, I think it's possible for a person to incorporate inside the original bill a memorandum of trust, because this is going to be a brand new action. There's not going to be a ruling from the judge that, yes, he sees a trust here. Am I going down the right path on that?
Yeah, but that's the first thing I probably want to get, a decree from the court on the validity of the trust.
All right, now I'm at a loss at how exactly we would go about doing that.
Well, I'm going to do a show cause hearing and ask him to rule on the facts I presented for him to do a determination on the trust. Give me a ruling out of the court, which is official recognition of the court that there is a trust.
Okay, and then from there, I can start the bill. From there, I would file the bill in equity. How do I get that decree?
Yeah, you'd have to file a court motion or something to invoke the hearing.
Okay.
Have them rule on the facts.
Now, going in and asking for a decree on whether or not there's a trust,
Gibson,
I'm going to have to
look up the Gibson book there. It talks about the decrees. Order out of
really. Okay, I've been jumping around so much in the Gibson book, I have no idea what it does and doesn't have anymore.
It's got everything.
I've been spending a lot on bills, so.
Got everything in it.
Okay, I will look in for decrees on how to get the decree. So that's my plan of attack, is to go ahead and send off to IRS for enforcement, alert them of breach of trust, and at the same time tie it up in court, just to simply keep any vultures from coming and stealing it in the middle of the night. So that's
do it
the action that I'm taking.
temporary restraining order or a preliminary injunction, which is equitable, and
Right.
or stay, whatever you want to call it.
Okay. All right. Anything else you could suggest that I'm maybe overlooking besides what you've already given me?
I'll tell you, that Gibson book is so full of jewels, it's like it's a gold mine. Even in the first, say, 20 sections.
Yes.
Just the basics there of how the courts have come about and what it's actually saying is, people are reading and not seeing what's in there.
Well, I tell you what, there's been a few things that I've read across and then see some different things on the chat and go back and read it again, and it's completely different once the understanding is there. As equity eyes develop.
The courts have been this way ever since the beginning, except just nobody's ever noticed it. And all they did was they conformed the laws, or what they're doing, to what it actually was all along. Because you take the Decatur Act in England, I think it was, the 1853 or 1877, I forget the date, but, and that's when they, combined the courts already back then. This 1907 Gibson book is talking about the civil action, the code practice, they call it. It was already done back then. Well, that's what we have, code practice, modern code practice.
Well, that book is good enough that I went ahead and ordered a paper copy of it. They do a reprint of it. It's about $80, but I think it's well worth it.
Yeah, super book.
Yeah. Dang it, I had another question there, too. It just fell out of my head when I was stating that.
They even say in there, I think it's in section 15, where there are two sides of the court. It says right there. One's the statutory side, and the other one's the equity side, or the exclusive jurisdiction.
Just the papers.
New back then to today. The same thing.
It's just all in a matter of the paper, the filings that we use.
Section 15, I think number 1 was the exclusive jurisdiction, or the equity side, and number 2 was the statutory side. No different from now.
The more I read this book, Tristan, the more it seems apparent to me that it's all in the paperwork, obviously. Now, I know I've heard the TAs talk a lot about your local state rules of civil procedure. If we're getting into the Court of Equity, are those civil procedure rules necessary? Are they equitable rules? How are they working?
The rules local might be a little bit different to get you into equity, but it's always been there. We just never could see it. Because like on Florida, if you're coming in with a claim like what you want to do, you come under Rule 1.060, which was
pleading special matters.
That's 6.1. 6.1. Yeah, one of the two, 6.1 or 6.0. I forget which one it is without me looking. But if you came in, you got trapped up on the at-law side, you use the other one. That would be the change of venue, the transfer.
Right.
And here they never talk about equity, but you're talking about a transfer of venue, and what else could that be? A transfer of venue from the at-law side to the equity side.
And so that's outlined in the civil rules.
Yeah.
So that would be one of the things. Okay.
And 1.0
those
takes
rules are
1170, and under J, all of 1170 is counterclaim, which is your bill in chancery, and under J is the transfer again. Transfer or dismissal.
Okay. All right.
There was there, but you just couldn't say it because they didn't come out and say, okay, this is equity. No, they were talking about different jurisdiction. And nobody knew they were talking about, really what they were talking about was equity. Different jurisdiction. Different venue.
Right. And the reason I asked that question was because, the more I'm looking into Gilbert's, the more this is starting to unfold to me, the less I want to cloud my brain with at-law stuff. And I wasn't sure how exactly the civil rules stuck in there. I was thinking that it was still, and I think it was it Bright the other night that said on the chat that it was Carl that said they're kind of both. They're the rules that actually still steer the court. You can use them to go from at-law into equity. So I want to make sure that I was correct on that, because if we can, if in my situation you can come right in from nothing and get right into equity, we're not gonna need a whole bunch of at-law stuff, especially if we're throwing that paperwork at them that they can't refute, that they don't know what to do with because they've never seen it before, because it's been so long since it's ever been used.
I think they can't do anything with it because they're on the other side. They don't have any equitable claims. They don't have any equitable counterclaims.
No. Most of the time we have fictions coming at us.
Like when Don and Doyle's case, when the party said that we don't recognize this to be legal. Yeah, absolutely. You're right.
It's lawful. What's the difference? I didn't get a chance to listen to that call. I heard it was pretty good, but I do have the recording. I'll go back and listen to it. I had plans to do it today, but my paperwork's tied me up all day long. It's amazing how you get something done, you go back through and you read it again, you're like, oh, no, I can't do that. You got to fix it up again. And then it happens all over again.
Yeah.
That's why I've been fighting all day long.
Section 15 is actually talking about the code practice, and then it must be in 21 and 22 then. 21 was the effect of the Act of 1877, that Decatur Act, and 22 is the classification of matters of equitable jurisdiction. And then under 1 it says the equitable or the inherent, and then number 2 is the statutory. And that's exactly what we've got today. See, everybody comes in the statutory and doesn't even know about the equitable or the inherent.
Shoot, it's not taught about it anymore. That's not taught about, and trusts aren't taught about.
Yeah, I wonder why.
Yeah, I wonder why. Exactly right.
How come the teaching of equity to the attorneys went from in 33 its high point to where it's they actually don't teach it any longer?
Wow, so they're going to continue the facade, all the fraud. If people know about it, they can know how to get out of it. But if
for one,
don't teach about it,
attorneys can't be taught equity because they can't come into court of equity. They got a bar card license. They're legal in nature, so they can only be seen on the at-law side. They can't come over and practice with a bar card. They have to come over as an individual man.
the license gives them permission to lie.
The lying is the truth over there, so you just have to get used to that.
Yeah, well, I guess that's true. Yeah, if it's all over in fiction land, it's, up is down and down is up, and the lies are truth and truth is lies.
And then we're starting to see that actually that courts are operating more equitably than what we think. Because when they hold you to last, we thought that they were, trying to hide things, which they are because they're trying to protect the privateness of the trust. They're trying to prevent commingling by keeping it private. When they send you for a psych evaluation, they're trying to keep the privateness private because they don't want you to bring it in and breach it. In fact, the 63 million statutes and codes are to protect the privateness of the trust. Because as soon as you breach those, you've started to commingle, and you've breached a statute and code, and they don't want you to do that, so they're protecting it. The statutes, they're actually the tutor teaching you by beating you up or killing you to wake you up, because you need to stop operating in this kiddie sandbox. Stop operating on the statutes and codes. You don't need it. Get out of here. It's trying to wake you up. Stop operating in commerce. Stop operating with statutes and codes. Don't need it. The only thing can be seen in that fiction realm, that public realm, is fictions. And you go in there and you fight and argue at that DC realm, that public side of the court, and you are operating as a fiction, period. I don't care what you say. Everything that the courts are doing points that out. We just don't want to accept it. If we accept what they're doing is correct and say, hey, let's go the other direction, now things start making better sense. It's like swimming upstream in the rapids. The real man can't swim upstream. He's supposed to swim downstream. Get in equity, you're swimming downstream. Things are a lot simpler over there. Only need less than 20 maxims. Don't need the 63 million statutes and codes to tell me, hey, get out of here.
Oh, that reminds me, I was going to say to the gentleman that was on just before me, just a simple Google search of equity maxims will bring up Wikipedia with all the maxims on there. And then from there, you can take them and go right into Gibson's and all the other books that we use and get a further explanation of them. You're absolutely right. And as we start to learn this process more, a lot of dots are connected that didn't make sense before, such as what you were saying about they send you for a psych evaluation because they're keeping it private. That makes sense now why they're doing it. Whereas before we just thought the judge was being,
tremendous
mean to it.
Yeah.
He's just trying to protect it. And the more study it is, the more you realize that you were really going the wrong way. And it takes a minute for it to reverse all in your brain. It takes more than a minute. It takes a couple of months for it to reverse all in your brain and start going backwards. And even then, you're still kicking and screaming.
Yep.
At least I am.
It's hard to get off of something that you've been taught all your life and you've been addicted to like a drug.
Yeah, indoctrinated almost from day one. Indoctrinated. That's a different subject. But now, typically when we send in the indentures, we'll pick the whatever corporation we're having problems with, and we'll send the indenture to the CEO, the high man, the CEO, the CFO, or maybe both of them. With the IRS, I think I heard you say that the Ogden office is, from what you can tell, is a private office. Wouldn't you want to send the indenture to the head man of the private office? Just a hypothetical guess there?
Yeah, well,
Turning my way off.
about everything that I'm going to be doing, he's going to be getting copies of it, yeah.
Okay. I'll have to do some due diligence and see if I can search that man up. Okay. Or maybe that agent. All right, Christian, I think I'm at the end of my questions. If I can remember anything else, I'll come back on. But I'm pretty sure all my immediate questions that I have right now that allow me to be able to continue to truck forward have been answered. So.
Okay, all right.
Thank you very much, man. I appreciate your help, your and Lisa's help very, very much. And I hope that the more people listen on the group and everything will start to get engaged in the questions, because I know I have a feeling a lot of people are lost in the group.
They are.
So
they are.
And anybody out there, Woody is my Skype name. If you have any questions, hit me up. I'll answer them as quickly and as best as I can.
The best way out of their fog is to go back starting on 11/7 of 2009, where NTT was announced, and come forward till the present and listen to all those audios. I mean, that's going to be a chore, but there's really no way out of it. Skype Faith to Trust and get the high point lists. There are about a dozen of them that are more important than the rest of them, but the rest of them are all fill-ins, and you need the fill-ins too.
Well, and I just remembered something else. I'll give a small testament. Since I've been listening, I've been successful in actually stopping a corporation in coming at me. I tied them up. They actually had to repudiate to a different corporation, which isn't stopping me. I'm still going forth. They're still going to be, the IRS is still going to be alerted on them. But I have seen the power of what's going on here. It has stopped these guys cold. They had to give it over to somebody else. So it is powerful. I spoke about that too much and I forgot what I was going to say.
Well, the equitable side is where the 900-pound gorilla rests there, and that's all we need to do is wake him up by, going over there and taking charge, because that's where our power base is from, and that's where our authority comes from the private side. That's equity, and we never knew that, and that's only accessible through a trust.
Yeah, and that takes a minute to get down, like you were saying earlier in the call, to get the private side and the public side down. It's
yeah, because the statutory lookalikes of the trust and the statutory lookalikes of equity, which are codifications, which are, they've taken the real thing and turned it into a privilege by codifying it, and then you get trapped up thinking you're in equity and you're not. Or you get trapped up in thinking you're in a statutory trust and you got a private trust, and it's not. So there's the counterparts on the outlaw side of what's over in equity, but they're the counterparts. They're not the real thing. They're counterfeit. And that makes it a little bit harder too. It's just like you have to come into the court with clean hands. That's an equitable maxim. He who comes into equity must come in with clean hands. But the codification of that and turned it into a privilege, and now you've got the doctrine of unclean hands, which is the counterpart or the counterfeit that's seen on the at-law side, and it's not equitable. It's a counterfeit. And you don't want to claim the unclean hands doctrine. You want to claim the maxim. They're just these little things, but there's only less than 20 maxims that I have to worry about. So,
and from those less than 20 maxims is what all the other laws have been built off of.
Yes, that's the maxims are the source of all the laws. Everything in the at-law side owes its source to the equity side, because the equity side is the grantor, the at-law side is the created side by the grantor. It must bow down. It is superior to the at-law side.
The created cannot be more powerful than the creator.
Right. But you don't have that power base unless you're in equity. If you're in the at-law side, you got no power, you got no authority, you got nothing. There, you're just, so I want to get out of there. When I know I got to get out of there, now I've reached the age of majority, and I can make the choice for the other side.
And that's the power to be able to choose.
That's where the enforcement of the trust is, because the The exclusive jurisdiction of the private trust is administered and enforced from the equity side, the private side. And that's why we go through a trust, private trust, because the exclusive jurisdiction is in equity.
And equity is a law of nature created by nature's God. There's nothing more powerful than that.
Oh, anything else?
No, sir. I think I still had something else I was gonna mention or ask you. I can't remember what it was, but I'm sure when I back off, I'll remember it. So if there's time, we'll come back on and ask it later.
Okay. All right.
Thank you, my friend. I appreciate your help.
All right. Thanks, Dan. Okay. Anybody else? Question? Star 6 followed by 1. Nobody? No questions? Star 6 followed by 1. Doyle, you're unmuted. Dan, you out there? Doyle, you're unmuted.
Can you hear me?
Yeah, got you now. Yep.
Sorry about that. I was muted. Anyway, I wanted to go back to the conversation you were having there with Darren related to the birth certificate. Who issues the birth certificate?
Actually, the mother issues it on behalf of the child, but gives the authority to produce it to the state.
So she's granting it to the state, and state, do they become the owner of the birth certificate?
They become the owner of it if it's a general deposit because it wasn't expressed to be a trust.
Yeah. So is it safe to assume that it could be a trust, and you are the beneficiary of the trust?
If you could express the trust and prove the trust, yeah.
Yeah.
Change the character of the birth certificate, which is general in its nature and character. Change it to now a trust nature and character. And you're the only one who can.
Yeah. Well, now, is a birth certificate, is it not basically the same kind of certificate as you would get on a vehicle?
Yep.
So the certificate is issued by the state, says that the vehicle is owned by the state, and you're granted user privileges to the vehicle. Is that not correct?
Right.
So using that analogy, go back to the birth certificate, and the state is issued a certificate, and it's got supposedly your name on it. Would that not mean that you only have the use of the name, but you don't own it?
Right, until you change it.
Until you change it. So is it not a problem to go out into the world, the outer world, beyond the private, and claim that you own that name?
Yeah, because you can't make that claim because you've given them the birth certificate.
Exactly.
Although you can change it back again, just like we do with the withdrawal and redeposit. Change its nature,
right.
Character.
But do you need to do that? It's a trust, and you have user privileges. Do you need to own it? Yeah,
because you have no authority of making a payment out of it until you do. You can't claim that you are the office of trustee on that account.
But if it's a trust, is it not the trustee's obligation to take care of the property?
Yes, it is, yeah. But you're supposed to be making payments out of the trust to them so you could extinguish the debt, but you keep on trying to make payments with these promissory notes and things, which are debtor-creditor instruments, and creating more debt, and these don't pay anything. And you just breached the trustee's duty.
Well, you've claimed the role of the trustee, haven't you?
Through their repudiation, yeah, by them sending you a bill, because that was the repudiation. And you never refused the repudiation and back onto them and told them that they're the trustee.
So you've got to get in front of somebody who's trustee and repudiate, as it were, and let him know that it's his duty to take care of the obligation of the owner. Is that not correct?
Right, and get rid of the legal title that you always have possession of and give it back to them. Because the trustee's got the possession of the legal titles.
Right. So
I don't want legal titles. Give the legal titles back to the trustee. And that way you flip and you inherit the beneficial right or the beneficial interest by flipping the legal liability back to them.
Right. Now, wouldn't it be a joyous occasion when they're saying, we want to give you a psych evaluation? Should not you be tickled about that idea?
Well, I don't think I'd be tickled about the idea, but I would need to recognize it as a warning that what I'm doing is I'm breaching the trust and I shouldn't be doing that. So I need to back up. and not go there.
Now, could you not also look at it from the perspective that they're going to deem you incompetent as a trustee, and therefore maybe appoint a trustee who can take care of your matters?
Yeah.
So in that light, it would not be a good idea to say, hey, I'm incompetent. Need you to get a trustee in here to take care of my affairs.
Well, already is a trustee. You just need to get shove it back onto them.
Yeah.
Refuse their repudiation and give them back the legal titles.
So would that not be kind of what you're doing when you're they're going to do a psych evaluation, determine whether you're competent?
Yeah, we'll get into a court of equity and ask for the termination of the guardian-ward relationship.
Okay. Well, it sounds to me like a trust, and from the get-go.
Ask for a final accounting on the guardian-ward relationship. That terminates the relationship right there. When you understand that when you ask for a final accounting, because the final accounting is for the termination of that relationship.
So
you ask,
would that be something?
That's the finalization of it, and that terminates the guardian-ward relation. Because now you've reached the age of majority that you know you have to terminate that guardian-ward relation. You're no longer a kid anymore.
Right. Now, could Doyle not use that in his situation and ask for a final accounting on the banker?
Yeah.
And could he not do that orally in front of the judge?
Yeah, but I would want to make sure that I got the court switched over from the outlaw side.
Switched over to the equitable side?
Yeah, I had to put some equity switches in there and make sure I got it switched over first.
That would be the dismissal and transfer?
Yeah, because it's really on the outlaw side until you flip it back over now.
All right. That's my line of questioning related to that first again.
That's the root of the whole problem, yeah.
Exactly.
If I ask for a final accounting on that account, then we terminate the guardian-ward relationship between me and them, and now I can take the beneficial position and start ordering them to start paying the bills because they're the trustee.
Right. So is it not true then that by going in and claiming the name and they get you right up front when you walk into court and they call the name and you step up and say, yeah, you're that person, is that not where they get you into the sand trap?
That was a repudiation and you accepted the trusteeship.
By claiming the name. Yes, I am Elmer Fudd or whatever, or John Q. Lunchbox.
Mm-hmm.
So they get you right up front. Almost as soon as you walk in the door, they get you in the sand trap.
Yeah, they need to. That's the first thing they need to do. Yeah, they need to identify the relationship first. That's what they're doing. It's like Gibson book, right? The first thing out that the Gibson book explains is that you got to identify the relationship to start out with first.
Right.
And if they
whenever you claim the name,
they get you to validate that it's DC, then it's all over. You're caught up in the trap.
Right. You're in the sand trap, and no way out unless you know what you're doing.
Yep, you're in a kiddie sandbox.
But the key to the trap is going in and claiming the name, isn't it?
Well, I don't want to claim the name on how they want to claim it, but I'm going to reverse it. But the UCCs, reverse it, change the character and the nature of the deposit from general to special. I went from outlaw to equity.
Could you not sort of block that whole process by not going in and claiming the name?
No, I think you need to go in, but you need to reverse it.
Yeah.
You need to go in and under equity, get it reversed from the outlaw.
And go ahead and make special deposit as opposed to general.
Right. It's like you got to go in there and show them who you are, but you don't want to show them who you are as on the general side, the fiction. You want to show them who you are as beneficiary on the equity side, the private side. Which side do you choose this day? Which side do you want to follow? You want to follow the godly side, the equity side, or you want to follow the lies and the frauds and the fictions?
Yeah.
Choose this day which God you're going to worship.
Now, coming back to the birth certificate, did you not bring that in as your SOI, that you're not the owner of the name?
Yeah, you could bring a birth certificate in there, but I would do the UCC process, withdraw and redeposit on it. Bring in the evidence that proves that trust has been flipped from, and the guardian ward is ended.
Bring in your evidence done a withdrawal.
I went over the Guardian Ward one. I don't remember what tape date that was. That would be a good one to go back and review for a lot of people. When we talked about the Guardian Ward, how to terminate that. I mean, that is so simple. All you got to do is ask for a final accounting. That's how simple it is. Just ask for a final accounting on the account. That terminates the Guardian Ward relationship. That's how simple it is.
Yeah. Now, could you put that in as a motion and put that in like into a case? Or do you have to do that verbally? So
There's a court of records being recorded, and I made public. Better make sure that that's going to be on the private side and it's being recorded so that some kind of record is being made of that. So I got a title that I can use if I had to. Otherwise, I would have to make sure it was in writing.
So it might not be a bad idea to go ahead and put a motion in and then do a verbal at the same time. Do a verbal or oral.
Yeah, but I'd make sure that everything's flipped from the at-law side to the equity side. Otherwise, they'd be saying, hey, we don't want to file any more documents in here. Or they'll say, hey, you need a psych evaluation. Well, then I know by that I haven't got it flipped on the right side.
Okay. Well, I was thinking maybe that might be something to do on in the credit card case when asked for final accounting.
Yeah, they're all the same thing. They're all the same problem.
Yeah.
They're all general deposits that need to be flipped onto the equity side.
Yeah.
They need to be done from general to special, which is general deposit to a special deposit, which is trust. Special deposits trust.
Right. Yeah.
Do the UCCs. Do the final accounting. Make sure the equitable has been claimed. The proper switches are in there to invoke it. The court of equity. Bringing that information in the court of equity.
Yep.
Get the decree on the validity of the trust.
Well, now, would that be all required to be done via the bill in equity?
Yes.
In a case that's already ongoing?
Yes.
I guess it'll relate back to the project numbered out.
Yeah, and then also it was, the avenue that we haven't really pursued could be the easier way is to come through the IRS and get it straightened around up there first, and have the IRS inform everybody else that hey, the account's been closed, it's been paid, it's been extinguished, and that way you probably wouldn't have to appear in court from that point on. But then, we haven't been pursuing that route, and anybody out there listening, probably that's the way that we should be going. That way you wouldn't have to appear in court if you had it in time.
Now, could you request from the IRS a final accounting?
Yeah.
Well, now, would you need to send that request to the CEO or the IRS, Rosario? Or would you need to send notice of it to several of the members of the accounting department?
Yeah, I would have to give notice to all proper parties that were involved, yeah. If I had enough time, I could do that first, and that way the court case would be extinguished. I wouldn't even have to show up at state court. Or if I knew something was coming up before it even got to court.
Yeah.
And then if I switched the whole account, the whole master account around, now my problem becomes trust administration so that I don't breach the trust and get back in the same situation that I just got out of. Because I can't go back there and operate the same way that I've been used to doing in the past. Because I got to change my whole total way of thinking, my whole concept of operating. Because I can no longer operate in the public as I used to, because I'm going to breach my own trust again. Once I flipped it around, I'll breach it. I'll be right back in the same mess, and they'll be back in there hauling me back into court for the same problem.
So, would you need to have your agent come forth, and that person would represent you as the trustee? And
yeah, the trustee
time you had
your bills. The trustee pays all your bills from that point on.
Exactly. But you would need to have an agent, wouldn't you?
Yeah. Mm-hmm.
I guess it could be the IRS.
Yeah.
I'm sure it's anybody else.
Uh-huh.
I mean, other government agents. Because I think we established that the government, the United States government, is the trustee of the trust. So any agent of the government would be possible agent or serve that purpose. Provided that he.
Yeah, the agent for the trust is really the president or the commander in chief. That's commander in chief's the public side. President is the private side. He's the agent for the trust. The trust is the United States. The trustee is the United States.
Now, you know that...
Instruct him to appoint the IRS to be another agent working for the trustee to take care of the accounts.
Right. Well, now, the courts being agents of the government, they're able to take care of that too, right?
On a microcosm basis, yeah. Those are the leaves of the trees coming at you.
Yeah.
But the master account is the macrocosm, or the main root. Pull the main root out, and all the rest of the microcosms all dry up. All the leaves of the tree dry up.
Well, they're not needed.
And then learn how to operate as a beneficiary and have your trustee pay your bills.
Exactly.
And he's not going to pay them as normally would under debt or creditor. He's going to merge them and extinguish them.
Right. So once you've got that relationship established, I can't imagine why anyone would want to breach their trust. If you know that the agent's going to take care of any issues you have, why would there be an issue or a problem?
Shouldn't be, unless you breach and commingle.
Well, if you know everything's going to be taken care of by the agent, there's no reason to breach, is there?
No, as they send me a bill, I just pass it on to the trustee and tell the trustee to pay the bill. Instead, the other way around. They send it to you, expect you to pay the bill as trustee.
Exactly. You just turned everything upside down, like we speak.
Yeah. Which way you want to operate on? You want to operate as trustee and be the debtor creditor and be liable for the bill, or are you going to be acting under equity and be the beneficiary, and now you can give the bill to the trustee and have him pay your bill?
Exactly. Which is the way it's supposed to work.
And who's got the final say-so of either realm? You do.
Well, yeah.
Which way do you want to operate?
Well, we definitely want to operate in the capacity of the beneficiary, but we've never been taught that's an option and how to do it.
Yeah, well, now we're learning. So now we've got to develop the skills to get that effectuated and learn how to administer things out of equity and do the orders and learn how to order these people around colorably so it doesn't look like they're getting orders, so that we can keep things private and don't mess around with the public nature of the public side at all.
Yeah.
Like the currency is made to flow on the public side within itself and go around and around and around. When all along the currency was supposed to flow from the negative to the positive, just like DC current, and flow back again. And we're the ones that's the switch, and we're not throwing the switch right. We're trapped in that currency up in the private side. It goes round and round and round, and it keeps on mounting up, mounting up, mounting up. And finally, if we don't get that transferred over and extinguished from the other side, it's going to blow up on us.
Yeah. We may already be near that explosion.
Yeah, because under DC current, negative Earth, lightning jumps up to the plus. And then once the connection is made, then the currency flows and it looks like lightning comes from the sky down. But actually, what you didn't see was it jumped from the ground up.
Yeah.
It flows from negative to positive. So the negative, being the public realm, has got to flow to the positive. And when it does, that's when the discharge happens. That's when it's extinguished. If it's just meant to be on the public side, and it just flows around and around and around in there, the charge just keeps building up. And if you get discharged by touching the other side, the plus side, eventually it's kind of, it's like it's going to blow up. If you don't keep the charge discharged, you're going to get a lightning bolt. Wham! And everything's going to be a rumble.
Yep. A big jolt.
Yeah, violent discharge, explosion. And I didn't have to do that. I could have discharged a little at a time as it came along. And I kept it going smoothly.
Right, like your monthly bills and right over to the trustee.
Okay, anything else?
No, that was the line of questions I had for this evening. I appreciate your time.
Okay, I appreciate your time too. Donna Lee, are you muted? Donna Lee, are you unmuted?
Hello?
Hi, Donna.
Hey, how are you doing, CW?
Okay, how about you?
I'm doing okay.
What you doing?
Man, I kept trying to get on Skype. I got on Skype. I got in the queue. I got kicked. I had to go somewhere. Then I got back on. Then I froze up. So now I'm on the phone. And boy, it took a while to get to tonight, but well worth it. I wanted to talk to you about something that I think could help people at law on the at law side with the foreclosure. If you're up to talking about that. Specifically, I had put in a discovery request for production of documents, and one of my family members' residential foreclosure cases.
Mm-hmm.
And the answer I got back, the response and answer was just ludicrous. and I wanted to tell you a couple of the things that were said. See, this response and answer is like 4 pages, and 5th page is certificate of service. But anyway, I asked for certain things like I wanted see the original mortgage, original note, title pages, abstracts, the assignment, proof of the chain of title, the launch to note, endorsement of launch to note, accurate statement of account, and all records and documents pertaining to the name. So that was just my first discovery request that I had put out to Chase. I'm sorry. It was just some bank. Okay. So anyway, the response I got back, first off, it says general responses and objections. Attorney-client privilege. I can't believe they're citing the attorney-client privilege. To the extent the request seeks the production of documents that are exempt from discovery by the attorney-client privilege, or because the documents embody or disclose confidential communications between Chase and its counsel or agents, I'm sorry, fictitious banks called BASE. I'm really slow tonight. I'm sorry. Please forgive me. Strike everything you just heard from your memory. Okay. They're saying due to the attorney-client privilege, the bank will not produce such documents. Okay. Now, the thing that's so stupid about that is at the closing table 4 years ago, there was no attorney-client privilege between my family member and the bank, right? But they're trying to state attorney-client privilege now as the reason why they won't produce the original note, the original mortgage, assignment, title pages, and such.
Right.
So I thought that was completely ludicrous. But, okay, on the second page, this gets really weird. Okay, now bear in mind this bank is the plaintiff. But on page 2, it says, documents not in the bank's possession. The bank objects to the request to the extent it seeks documents which are not in the bank's possession, custody, or control, and as such exceed the permissible scope of discovery under Florida Rules of Civil Procedure. Now, how could someone claiming to be the real party in interest not have the documents in their possession, custody, or control?
Yeah, well, that's the proof that you need right there that they didn't have the note then. That's what you asked for. And they're saying it's not in their custody or their possession?
It's not in their possession, custody, or control.
Okay, then who are you guys then?
Exactly. And then further down, CW on the
by your own admission, you're not the real party in interest with the right for enforcement.
What was that last that you said?
Obviously, by their own admission, they're not the real party in interest with the ability or the right to enforce.
Exactly. Oh, and then further down, see, they've got all these different excuses like work product, proprietary information, irrelevant documents, improper purposes, no concession of admissibility. But further down on that same page, it says, get this, unnecessarily burdensome and overbroad. Okay, and it says, to the extent the request is unnecessarily burdensome, overbroad, or oppressive, and the production of documents in response would require the bank to research, reorganize, repackage, or transport voluminous documents. You have to bring them in on a freaking forklift, right? Voluminous documents, destroying the integrity of bank's business records. The bank objects to the request.
Yeah, but they're making those kind of statements because they can, because not you to rebut what they're saying, and all that is a deck of cards that if you blow on it, it all collapses. I understand it. When you look at that, it makes you really teed off that they could come back with something like that, but they can't.
Well,
and what you got to do is you take it like a grain of sand or a grain of salt, and just say, hey, what they're coming at you as a paper tiger. So
right.
It would be my defendant's notice of objection in opposition to whatever they're doing there, and the action to foreclose the property, whatever it is. And the one who seeks the aid of equity is governed by its rules and principles, and equity is not necessarily enforce a legal right if to do so would be inequitable. And you're in Florida, so that's Machete versus Campbell. And then number 2,
machete like a axe.
MACHTEI versus Campbell. That's 102 South 2nd 722. Then number 2, This court does not have jurisdiction on law over the action. Plaintiff doesn't demonstrate with competent evidence to being the real party in interest, withstanding having the right to enforce with a sworn complaint or an attached sworn affidavit in support, or a competent fact witness supporting holder and owner status of the note and mortgage right, in this case attached to the original filed complaint. The court, sui sponte, should dismiss the case for lack of subject matter jurisdiction. See Florida Civil Rules of Procedure 1.140B1 and 1130A. Point 3. This court is not a forum for clever use of smoke and mirrors to evade court responding to lawful discovery requests. Plaintiff needs to, quote, abide by the rules, unquote, if the integrity of the court is to be upheld. Next quote, the integrity of the civil litigation process depends on truthful disclosure of facts. A system that depends on the adversary's ability to uncover falsehood is doomed to failure, which is why this kind of conduct must be discouraged in the strongest possible way, unquote. That came out as a direct quote out of C. 2007 Handbook on Discovery Practice that was cited in Cox, 706 South 2nd at 47. Number 4, defendants' discovery requests were not objectionable where the discovery sought is in plaintiff's possession and or control and is according to Florida Rules of Civil Procedures 1280B1, which is discovery, which in pertinent parts states that the parties may obtain discovery regarding any matter not privileged that is relevant to the subject matter of the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other party, ... reasonably calculated to lead to admissible evidence, unquote.
That sounds good. That sounds really good. See, what I have in the case was they had 30 days to produce the documents according to the rules.
Right.
And so I waited. I always like to give this a little bit longer, just to look like I'm, not Miss Johnny on the spot, 30 days on the dot. So I just
give,
in the
I think it's
motion to
30 plus 5 before you come back in.
Oh, okay. Well, I gave them 45.
That's fine. Yeah. But you got to, if you're in Florida, you got to give them an individual letter out of court that demands that they comply with discovery rules. And then once you issue that and give them an opportunity to cure, then you can keep moving forward on your discovery and put in for a show cause hearing why not they should be ordered to court for them to produce the documents. Because what they're doing is, my next point here is number 6, plaintiff is using dilatory tactics demonstrating bad faith with all of defendants for discovery requests here that I had. Plaintiff is acting inequitably by being evasive and not responding to defendants' many requests for discovery, prejudicing defendants' rights. See Florida Rules of Civil Procedure 1380A3, evasive. They just say, okay, client-attorney privilege on documentation required by law to prove that they are owner and holder of the note and mortgage. Sorry, that don't cut it. And if you keep moving forward on pushing ahead that they're supposed to give you the discovery, you'll end up winning because they don't have the documents. And you use the court through discovery to certify that they don't have them.
What I noticed is, I believe that for a note to go from, there's 4 steps for a note to go into a pool. I believe it's from the originator to the depositor, the originator to sponsor to the depositor to the trust.
Right.
I think, or maybe 2 and 3, I have them reversed. But there's no assignments whatsoever in any of these. I mean, I'm just blown away. There's not assignment 1 in anything. There's never been any records attached to the complaint. The note itself is endorsed.
You have to use the court to certify that they don't have the documents. And when you do, you win. That's exactly what you want them to do. And they don't have the documents. They do it every time. All you have to do is keep carrying this forward and getting this certified in the court, moving it to a contempt hearing. And by the time you get to the contempt hearing, or it gets to the point where it looks that you've done multiple discovery requests and they're falling down on all of them, they're doing inequitable actions, in bad faith, and now equity, you can come back in under equity and smash them.
Okay. Now, I mean, in your opinion, would you go ahead and have a hearing on the motion to compel production of the documents?
No, in Florida, you have to write them an outside of court letter sent privately, demanding that they produce the documents according to the rules and give them an opportunity to cure. Then once you get a private letter, then you can schedule a show cause hearing as why they should not be, an order should be issued to order the plaintiff to produce the documents requested.
Now, let me ask you this. Okay, you're saying to send a letter outside of the court to the plaintiff.
Yeah, that's a special rule in Florida only, as far as I know. There may be other states that do that, but in Florida, I know you have to do that.
Okay, so but you're not putting any trace of that into the case itself?
Yeah, I do, because now I've followed what the court says to do on the local rules, and it says I got to do that in Florida.
Okay. Now it sounded like you were saying to send a letter with the demand to produce and the opportunity to cure all in one.
Yes.
Okay. Oh, that's cool.
This is an opportunity to cure your breach, because according to the Florida rules, you were supposed to produce these documents, and I'm giving you this opportunity to make it right, or else in-court proceedings will be pursued.
Okay, so
Your last outside court, because after this, I'm going to come at you with an order, and I'm going to get you in contempt eventually.
Okay, so but would you copy that into the case as well?
Yeah, because I'm going to attach it to, according to the rules, it says that I must do this, and I'm going to attach a copy of that I did it, and now I've complied with the rules for my show cause hearing, because I can't go to a show cause hearing unless I've done the letter first.
Would you send that registered or certified?
Absolutely. Certified mail. I got to carry the record that I sent it.
Okay.
They can't say they never got it.
That's beautiful. That is beautiful. It's amazing. It's amazing all the whodunit.
Yeah, but we're just...
I feel like a show dog.
create more records to prove that they don't have the documents.
Right. Now, let me ask you this. So, say they have all this notice that I need these documents. I mean, there's a lot of these companies out there that just materialize and make them appear out of thin air, right? So, what if they bring in documents later on and they're just, manufactured sham?
No. They can't bring in documents later on. Once the 30 days went by on the original request, they are time barred.
Really? Oh, okay. You know what, Christian? Wouldn't that be funny if wouldn't that be funny if I took someone to court, and they wanted proof that I had standing to be there to proceed against them, and they wanted proof that I was the real party in interest, and I said, that's just too burdensome. It's just unnecessarily burdensome and overbroad for me to prove that I have a case against somebody. It's
they get away with that because they can, because the people don't know what to ask for, because they don't keep moving forward on their case.
Right.
Start arguing the other party's case. No, I don't want to argue their case. I want them to argue mine. And now you got them off balance, and now they're arguing your case. You keep moving forward on your case on your end. You keep pursuing the documents that they're supposed to produce them now. Are you using interrogatories and admissions also?
Well, I started out with the production, and they're like not giving me any of the production. So next, I'm going to go with the request for admission, and after that, the interrogatories, and then the depositions if needed. But I might not need even need some of the other stuff if they can even produce the. I've had a lot of people tell me, oh, you need to go do this and that and the other and do all this private stuff. And I'm like, I've already done the indentures and everything. And so as far as I'm concerned, the trust is terminated. And, but
the thing
is,
you want to hammer the at-law side that keeps on rolling over you before they roll over you. And
right.
You're going to do that discovery.
See, this is like a beautiful time, though. I mean, a lot of people freak out and they just want the case to be over, and they want something to show up on their court sequence of events. And it's like, this is the perfect time. I mean, I'm not talking about the way draw stuff out. I'm talking about if someone claims that they have a right to sue you, they should easily be able to come up with these documents. They should have had them attached to their complaints, you know, the business records and such, right?
Rules, I think it's 1130A, it says that you must attach the documents that you rely upon to the original filing, really, and file them into the case. And you must have standing or real party in interest. You must be the real party in interest at the filing. You can't attain real party in interest status somewhere into the case. If you do, the appropriate method is to dismiss the case and go refile again with standing.
Right.
So they got to have the original documents that they filed are the controlling documents. They can't bring in documents later on to achieve what they should have had at the beginning of filing. If you can prove that standing at the beginning, then that case gets dismissed. And you do that through discovery. I would be sending them interrogatories and admissions also, along with the production, and send them another request for production of documents since they didn't respond to the first one, and demand it again. And when they refuse the admissions and refuse the interrogatories, now I would refile those again, and now you've got production, interrogatories, admissions with, say, at least 2 requests, so you got 6 different times that they refused to produce. Now, things begin to look unequitable to the court. They are obviously operating in bad faith. And then you can go to a show cause hearing, get an order for them to be ordered to produce these documents, let that run, and when that runs out and they don't produce the documents, then you go into another show cause hearing why they should be held in contempt. By that time, they'll dismiss the case.
Well, you know, I think people really need to realize, you know, that right now with this bank not producing the documents, they're in the hot seat.
Yeah, because
I'm very much enjoying this.
In Florida, your construction company states that court decision that was established that you must be owner and holder of the note in order to foreclose in Florida. And also, I think it was a JMAR case. I forget what that one is.
What was the first case?
Your construction company. And the other one was JMAR versus somebody. I forget who that was, though.
I'm sorry, I didn't really hear the first word of the construction company case.
Your construction company.
Oh, D-O-O-R?
Y-O-U-R.
Oh, I-O-U-R. Okay, and like you know and I know that they're not going to produce this stuff, and they can't produce stuff.
What you want.
This is fantastic leverage.
They hand you the win on a silver platter, if you know what to do with it.
Right. Well, you know, my thing is,
Everybody claims, you know, they cry and, oh, they didn't produce the documentation. They didn't do this. They sent me this nasty letter and stuff, and they said this and they said that. Oh my, that's what you want.
Yes.
You win that way.
Yeah. I'm loving this because I can default them. I can get them in contempt. I can get sanctions. I can get all kinds of stuff. You know, by them. See, this is a beautiful, beautiful time in a foreclosure because first off, they can't foreclose on you. They can't ask for summary judgment when discovery is ongoing.
Right.
So it's a beautiful time. So, but at the same time, we know that they're not going to provide the discovery. I mean, this is like a beautiful thing on the outlaw side because it's like you can really put the hammer down on them.
Now you can stop the outlaw side, save your house. Then you can come back in and use NTT to merge the title and make the payments. Get it certified and get it issued out of the records that it's been extinguished.
Beautiful.
Then get rid of your possession of your house. You get rid of your possessory title and put it in trust.
Yep.
Become the beneficiary, and your problems all go away.
I love it. It's great. It's fantastic.
Then when they come at you the next time, you can say, well, I don't own the house anymore. Some trustee owns the house.
I'm user-fronting the house.
I'm not the trustee on the house. You can't get me for the liability of the house. Go find the trustee, whoever's holding the real trustee title, possessory title. Go find him.
I kind of suspect it'll be someone's name on a tombstone somewhere. Yeah, that's the trustee. Get him into court. Good luck. Well, this is great. This is great. I really don't have respect for 99.99999% of the attorneys out there. They just get floored at me because I don't think that they're gods. I see them for what they are, and they see me, them, knowing that I know exactly what most of them are about, and I don't get cowed by their verbiage. I mean, I tear their stuff apart. They don't like me.
They're
don't like
using
me at all.
act, which is a result of excusable neglect. They're failing to act. So, they're using dilatory practices. They're stalling. And their claims are really unsupported in law, and they contain no well-pled facts or grounds in support.
Well, there's nothing in there about injury at all, and that's one of the elements of the breach of
They don't
contract.
state any specific facts showing an adequate cause shown for why plaintiffs should be granted anything that they're asking for.
Right. In jurisdictionary, I mean, one of the elements of is injury, and all they do is they don't even put a dollar amount there. I mean, it's they just have like the S with one line through it.
Yep.
That's not even a dollar amount. That's
The rules state that the reason why they could ask for, say, an extension of time or grant that is for excusable neglect, and they haven't shown any adequate cause shown to, or any ground sufficient as a basis for that cause. They have no adequate excuse to not respond according to the rules timely.
Wow.
They don't have any legitimate or legally non-frivolous reason to refuse to answer discovery requests. You should go after them, say, with attorney's fees and costs for preparing and defending the motion, and go for sanctioning.
I like that.
Where a party fails to respond to discovery and does not give sound reason for its failure to do so, sanctions should be imposed. See Ford Motor Company versus Garrison, 415 South 2nd, 843, Florida First DCA, 1982.
Was that Garrison?
Ford Motor Company versus Garrison, yeah.
Garrison, okay. You know what? I found so many problems with like the note, for example. There's all these notes. All these notes are they're endorsed in blank. There's nothing there. There's nothing there. And I found one assignment on one of the properties. I'm dealing with 6 right now. There was one assignment on one of the residential properties, and it was where Mears was actually the originator or the lender shows an assignment straight to the trust, which went from A to D, that's completely against the rules. It's supposed to go from A to B to D, but it went A, D.
You have
it was
a
really
copy of
crazy.
Pooling and servicing agreement?
I'm sorry?
You have a copy of your pooling and servicing agreement?
Yeah, on that one.
Yeah, for anybody who needs to know how to track that down, I put a post in there on the chat group, NTT chat group, of how to track down your pooling and servicing agreement. With that specifies what and how and when and where everything is supposed to take place according to your note and mortgage to put it into trust. If they violate any of those particular rules that were set up, then that's grounds that they don't have real party and interest standing and to foreclose because it was improperly placed into trust.
I found mine in the trust, and it didn't have my name. It had the account number, the city, the zip code, the dollar, the loan amount. It had a lot of information in there, but it was obvious it was mine. It was the exact same interest rate and exact same mortgage amount, et cetera, et cetera. It shows who the lender is. And which was it wasn't who I sat down at the closing table with, which was really interesting, the original lender. But back to that assignment that I found from the originator to the trustee or the trust. It was really interesting because I was looking at the date, and the date that this assignment, one-page assignment, was notarized. It was notarized, say, for example, on, November 3rd of 2003, but up in the top of the assignment, it spoke of something that had occurred 3 days future. It's like, what are they getting a time capsule and be in present time and go back three days into the past to do? Does that make any sense? I mean, things are getting notarized when they're notarizing something that's happened 3 days in the future from the notarization date.
Mm-hmm.
Just crazy stuff going on. I mean, it's hard to keep track of all the, when you're trying to backtrack and, make up documents, make them look like they've been there all along.
Well, I would put in a notice of objection to whatever their plaintiff's motion was that they sent you.
Okay.
I'll put a notice of objection and motion to strike that document. So,
Okay.
notice of objection and motion to strike plaintiffs, whatever they're called their motion.
Okay.
Don't let that motion
Oh.
on a plate. Knock it out.
Okay. Yeah, and then on a lot of these foreclosures, they did the count to reestablish the note, been lost or destroyed. Then all of a sudden they have the note and they file it into the case. The original note and mortgage.
Right, that's to surprise you.
To surprise me.
Yes, that's to surprise you. So you're like confused and you don't know what to do because all of a sudden they got the note. No, I object because I've been asking this for discovery for 6 months and you never produced it. Now you just can't produce it out of clear blue sky. That's a surprise.
Yeah, and it was supposed to be with the original.
When did you
filing.
get possession of this? This is what I want to know. When did this all of a sudden pop up? Because if you had it in your possession, why didn't you just hand it over to me? Because I wanted to inspect it.
Mm-hmm.
You can't just bring this note in here now.
Dated, though.
That's a grounds for to vacate the judgment.
Wow. Yeah.
But put in a second request for the same documents that you asked for the first time. Run it through the court.
Yeah.
Give them another 30 days. Get them to default on that again.
Default of twice.
Put some in there. Get them to default on that. Put some more admissions in on top of that. Re-ask for the same thing you asked for the first time. Do the same thing on interrogatories.
Yeah.
Now when you got 4, 5, 6 different requests, then they are obviously stalling because they don't produce nothing. You just won.
I think they're probably hoping that I'm going to die or go away or something. I don't know.
Now the truth
I'm going to keep.
now is that they don't have any documentation to foreclose on you at all.
Right.
And then you can get the case dismissed.
Hey, isn't it in Florida we have if they put in a motion or something, we have 15 days to put in a motion strike or
10.
10 days? Okay. And what would you do if you had taken over cases from a family member that didn't answer to anything and stuff's in there now? Is it set in stone, or do you think the discovery would help with that?
Yeah, I would move forward on discovery, yeah, because if you don't, that's the only way you're going to win.
Okay. All right. Well, I really appreciate all your time and help and everything. It's absolutely wonderful. Thank you very much, Kristen.
No problem.
Yeah, you probably got people waiting, so I'll go and let them talk. I don't want to pull it down. No. I'm being silly. It's a full moon, in case people are wondering.
Oh, that's why. Okay.
That's why.
Well, move the court as the defendant for an order striking plaintiff's motion for whatever they asked for.
Okay.
Because it's legally insufficient, inadequate, irrelevant, frivolous, and without merit incorporating herein all this stuff.
Okay. One last thing. You said that, send a letter privately requesting the discovery. And how many days was that to give them?
Well, after I sent the letter, I only give them like 3 days to respond. If 3 days to respond. If you don't respond in 3 days, Or if you want to be generous, give them 10. 10 seems to be the thing if they operate in a court.
Okay. I'll give 10 days. Great. Fantastic. Thank you so much, Christian. I really appreciate it.
And come back in with that they're prejudicing you. They're prejudicing your equitable rights.
I like that.
And then
I like how that sounds. Not how it feels.
You equity must be doing equity, and they're not doing equity by holding up discovery requests, which are lawfully required to do by law. You got to produce these documents.
Well, I'm going to nail them.
They can't use the court as a clever use of smoke and mirrors that everything works for them and not for you. They must abide by the rules if the integrity of the court is to be upheld. And you're in Florida, then seek the 2007 Handbook on Discovery Practice. That was cited in Cox case. And use the direct quote out of Cox in your document.
Okay.
And then there's another case, I forget what it was. I think it was Stiles, or it might have been State Street Bank. Had to do with the production of the note and the mortgage in order to foreclose. And they can't claim that this is client privilege because the note and mortgage is not client privilege.
I know.
Stop
I know.
thinking rules to think you can get away with it, because I'm going to come at you and I'm going to sanction you. Write a nasty letter to the bar under a bar complaint. Every time they do something wrong, write another bar complaint. And they get 3 or 4 bar complaints, their insurance doubles.
So they'll keep taking the bar will keep taking complaints from
Yes.
on the same attorney and firm?
Yes. Every time they break a rule or they're operating immorally, according to their code of conduct, write a bar complaint.
Okay. That's beautiful. Beautiful. Well, fantastic. I really appreciate this very much. And I'm going to be all over them like a deep suit.
I mean, in this case, we asked for discovery. You know, the plaintiff's conduct was a rebutted presumption, has prejudiced defendant through its bad faith, dilatory, willful, non-compliant, disregard, and gross indifference actions. Over a 9-month period since plaintiff such and such a date, defendant has requested 4 discovery requests, 2 requests for production filed on such and such a date, and 1 request for admissions filed on such and such a date, and 1 request for interrogatories filed such and such a date. Plaintiff has not responded timely to any of defendant's requests. This is a bar to defendant's preparation of his defense and precludes defendants from preparing counterclaims.
Wow. That's beautiful.
Next point. Plaintiff so-and-so has not responded timely, nor have they given any timely sound reasons for its failure to do so with a timely answer other than for a pattern of delay and recalcitrance in requested discovery production, admission answers, and interrogatories. Plaintiff so-and-so has not asked for any protective order protecting privileged matter within the time frame. And that's key, within the time frame. You only got 30 days. If this was privileged matter, you should have claimed it.
Ooh, nice.
If you didn't claim it within the 30 days, you waive it, and you can't claim it again.
Ooh.
Plaintiff so-and-so is now time barred to respond or object.
Beautiful. Okay, so if I put in a motion and they don't respond within 10 days, then, but they just say they put something in on day 11.
You only got 10 days. Well, usually they'll give you 10 plus 5 for mailing. So if they don't do it within 15, actually 10 days is the cutoff. They need to get it in before 10 days. After 10 days, it becomes questionable.
Okay, so if you put a motion into a case and just say their response wasn't postmarked or whatever by a certain date, and then on day just say day 16 they try to put something in, what would you put in? I mean, a motion.
The rules are the rules. You've got 30 days. If you don't get it in within the 30-day time limit, you're not allowed. If you had a tummy ache that day, doesn't count. Doesn't cut it. You still only had 30 days to get it in there. The only excuse is for excusable neglect, and you didn't claim that. In other words, for good cause shown, you're negligent, and that good cause shown would be, I'm in the hospital and there's no way because I was operated on that day. That's excusable neglect. Anything else doesn't cut it. That's good cause shown. Everything else is not. You can't just come up and say, well, you know, I just didn't feel like doing it today. No, you had 30 days to respond. These are the rules, and if we're not playing by the rules here, we got no justice. And what works for you has got to work for me. It's got to be fair. It's got to be equitable.
Right.
Now you are operating inequitably. You didn't ask for an enlargement of the time within the time limit. You didn't ask for anything at all. And you, after the time limit, you come back in and you come in with this frivolous crap? Sorry, Charlie. You're going to be tuna meat for me.
Oh, okay. So I had put in the request for admissions, right, or discovery request for production of documents, and it was 33 days later. They opposing counsel asked for an extension of time to answer.
Sorry, you're time barred. Should have got it in before then.
Oh, so what I read to you with the
all frivolous. This had to be in the court filed within 30 days. And ask for
the documents.
Pass.
Oh, okay. So the documents not in Chase's possession or the bank's possession and unnecessarily burdensome and overbroad. All that garbage is.
Dilatory tactics.
What is it?
Dilatory tactics.
Okay. So I can't even use this, though. I can't even use the paper, their response, and showing that they don't.
They can't use it if it was past 30 days. It's stalling tactics, dilatory tactics, recalcitrance. All frivolous. Not done in good.
Okay.
Not done timely, and now it's time barred.
Okay, so let me ask you this. If it's been over 30 days since they put in their motion for enlargement of time,
the rule says
I barred from striking it because it's over 30 days.
No, you're not time barred for striking it. You can strike it at any time. In fact, you got to come put in a motion to strike it because it is past 30 days. The rule says who shall furnish the information available to the party. Each interrogatory, whatever discovery, shall be answered separately and fully in writing and under oath, and ... The grounds for the objection shall be stated. And it says here, any objections within 30 days after service, not 31. If you object, it's got to be within 30 days after the service. If you don't object,
they're talking calendar days.
You can't object. You waive it. You're time barred.
Okay, but I still have to send the private mailing with the request for the production of documents.
And they got to respond within 30 days.
Okay, give them 30 days.
That's what the rule says. You got to give 30 days for production. Interrogatories, admissions, 30 days. That's all they got.
Oh, okay, but I'm talking about the private letter you send to them. That's 30 days also?
No, that's like I give them 10 days.
Okay, for the production and opportunity to cure.
That's different, yeah.
Okay, all right, I got it now. You set me straight. Man, oh, this is great. What great information. This is fantastic. You're like 100 attorneys in just one guy. And you have clean hands. It's a miracle. Great. Wow. I'm so glad I finally got on with you tonight. Seemed like it took forever, but I'm glad I finally got there.
Once they do this stuff past the time limit, defendant's rights have now been prejudiced, and plaintiff, by the willful action, has done bad faith, or precluding the defendant from raising a defense and counterclaims that will be unavailable or endangered in this or a second suit. Defendant is unable to raise proper defense, leading to a possible defendant's default by plaintiff's bar to discovery. Plaintiff's prejudice is causing irreparable harm and loss of defendant's right of possession and equitable interest in the subject matter real property in this action. Use all this to strike their motion.
Okay.
At least rebut it with this. Don't let it stand, because if you don't rebut, say, or what they sent you, what they say in there, it will stand.
Okay, and I can also go back and rebut strike the original note and original mortgage filed in the case because it wasn't filed in with the original complaint.
Yes.
So they were time barred on that also.
You have to at least put in a copy, copied from the original, and that copy must be attached to the pleading that they filed on the original filing. They must have a copy of the note and the mortgage drawn from or copied from the original, not one pulled out of the county recorder.
Okay. So, I'll just go back through
and the original filed documents are the controlling documents of the case to establish real party and interest, real party owner, holder status, holder in due course. If they don't have that status from the beginning, they can't establish it sometime later in the case. Proper action is the motion to dismiss, and then they need to go get their documents that they're defaulty on and refile the case.
But you know what? In Florida, we have, as you know, I've heard you speak on this before. Since February 11th of last year, they have to do the certified complaint,
right,
where sworn under penalty of perjury.
That they have a mortgage.
Right. And there was actually one of these foreclosure cases.
Okay, now that was filed past that date. Now that rule and it makes it applicable in your case. Now, if they've swore that they have that documentation, why are they not producing it?
Right.
Obviously, they've lied on to the court and swore to the court that they had it, and they're not producing it. Now, you could come back in with a counterclaim and claim that they are committing fraud upon the court, and they should be sanctioned because they're not producing what they swore that they had.
Yeah, that was in one of the cases. One of the residential foreclosures was after February 11th of 2010, and it was not a certified affidavit or verified complaint. But also, if they put in a motion to redo their complaint, that amendment that kicks in also. If they have to do their complaint, then their complaint they have to make sure it's a verified complaint because that's retroactive, or it kicks in if they do it after February 11th, 2010.
Right.
So that's really cool too. It's long overdue.
Well, they certify that they've got it, not produce it, and
right.
then claim it's client privilege.
Right. People really need to read these things from these attorneys. If they really start looking at them, they'll see how ridiculous it is.
All you got to do is strike a match. Burn it up.
Strike a match.
Burn up the paper tiger.
I love that.
Put it in the motion to strike. Put in all the stuff we're talking about tonight.
Yeah.
Now you just totally ripped up their piece of paper. You just burn it up. Come back in and ask again for the same thing. I'm going to give you a second request for production to the same exact thing I did on the first.
Do we really need to have the
and warn them this time. Hey, no games. I'm coming after you with sanctions if you don't produce these documents.
Wow, that's great. That would seem to be very ridiculous to have some buffoon there in a 3-suit trying to say they have.
You're not going to be a parasite sucking off of me. That suit you got on's mine.
That think their ship came in or something.
Yeah, that Armani suit you're wearing came from me. You know, and people like me. Stop sucking on me, parasite. You're not doing politics here. Many blood-sucking insects. Many, and ticks. Blood-sucking insects. Politics. You're not doing politics with me.
Hey, I wanted to ask you about when I go into court. It's really crazy because it's not even in a courtroom. They just take you off to the side, like in a small room with a table that fills up most of the little room.
Yeah, like the money changers in the temple. Ching ching.
What is that?
Ching ching. Next. Ching ching ching. Next. All for the purpose of commerce.
But they don't even have the facade of it being a court. It's just insane. It's like you go up to the 4th floor of the courthouse. You go through the scanning machine. You walk down this little incline till you get to a podium that has a big placard on it that says checkpoint. And you have to, all the administrators, judges, whatever, they're all way down halls behind locked doors. And the bailiffs wait around to gather everybody up who's going to go see, one of the judges. And they go through this big show of unlocking this secure door, and everybody files behind the bailiff like ducklings, and then they tell you to go into a room and sit down.
Yeah, come on into the gas chamber.
Yeah. We're having a barbecue.
Papers, please. Let me see your papers.
Yeah. And then you just sit there and wait to go into just an office that's just got a big table, like you're going to sit down at a dinner table. There's just nothing there. It's crazy. And the attorneys don't show up. They're all doing telephonic appearances. I could be there for 2-3 hours waiting, and when they finally get ready to have me walk into this little room, they call the attorney on the phone. He could just sit in his office over in Fort Lauderdale or Naples or Jacksonville or whatever and just wait for the phone to ring,
Yep, we made those laws.
Who did?
We made those laws.
Well, I wasn't there when the boat was...
No, they had to do government.
But it's ridiculous to have an attorney that's 100, 150 miles away.
But where were we all when the laws were being made when we should have said, no, this ain't right? We were nowhere. Back home watching our TV, taking Johnny to the soccer game, doing this, doing that, and trying to live life, ignoring what was really happening. And all our rights were being flushed down the toilet, and we didn't care at that moment because nobody was coming at us. Now we're all paying the price for our irresponsible actions of doing government when government should have been done.
Well,
there's no
when
to
people
blame.
are paid very, very well.
How come the attorneys can go through one gate and you got to sit there and take all your clothes off and show everybody everything and come through the other gate? How come the attorneys...
Well, it was kind of funny. It was kind of funny, Christian, the last time I went to the courthouse, because sometimes I forget to take my gun out of my fanny pack and leave it somewhere else. But I was going through the scanner, and I was like, do you guys ever have people like bring weapons in here? Because they're like, it's like crazy. It's like worse than an airport times 10, right? And I said, yeah. The guys were telling me, oh yeah, we've had 2 attorneys bring guns in here. And I said, you're kidding me. And they said, no, nobody else ever has, just the stupid attorneys. Like, he told me. And I said, what happened to them? And the guy was telling me that, they were arrested on the spot, taken right to jail. I couldn't even believe it, you know. So for some reason, it's weird because I think if the only people there that are bringing in guns are attorneys, I think they're more worried about the attorneys than us, regular people, you know.
Well, we don't like the things that are being done. Most people aren't doing anything about what they don't like. They're not going
right.
to the government as being with those rules are being made, and speaking up and forming committees and getting these rules defeated. If we don't do anything, we waive our rights. That's what
right.
we're sleeping
you know what?
on our rights. So we have.
These people,
we are not doing what is equitable ourselves.
Right, but we sure are trying now. You know, we have all of these people that work for government that they have great jobs. They don't work on weekends or holidays, and they get fantastic benefits, and they get paid a lot. And people were put into the position.
We would be doing work for them. We wouldn't have to pay them because we would be the ones that would be getting that.
Right. There are supervisors that were supposed to supervise the workers that they were paid very, very well too, with great benefits and all that. They get great health care, dental care, 401ks, all this stuff. They get great retirement packages. We paid for all this, putting these people in these positions of trust to, for our benefit. And, are we supposed to sit there and hold their hands and watch over them 24 hours a day? When can we ever get anything done?
Yes, that's our job. The CEO of the corporation does nothing but watch and make sure everybody else does their duties. And that's what we must be doing. Do we think that we're going to appoint foxes of the chicken coop and no chickens are going to disappear? Who's watching the foxes? We're supposed to be watching the foxes so they don't take any chickens.
Right. Yeah.
We're supposed to be doing government. And if we do government, we won't have all these problems.
Yeah. Well, I do take some responsibility in it. But I'll tell you, some of the stuff that's going on it's like mind warping how well thought out and involved a lot of this.
We can change it all. We're the only ones who can. And until we do, it will continue to get worse.
Well, we need to change all this then.
Yes, we do.
Yeah, we need to change, definitely. Uh-oh. I'm calling somebody. I don't know what happened. Okay, cool. I really, really appreciate all your time and help. I'm being told I'm being very long-winded. So I better get off and let somebody else get on. And I really appreciate all your time and everything tonight,
all right.
CW. And of course, my love goes out to the Lisa and TAs and everybody. And wow, what a great call. Fantastic. Really appreciate it.
Okay, thanks, Donna, for coming on.
Thanks, CW. Bye-bye.
Nobody else is in the queue. All right, press *6 followed by a 1 if anybody wants to raise their hand and ask a question. *6 followed by a 1. Got time maybe for one more, and that's it. Any questions, anybody? *6 followed by a 1. Going once? Going twice? 3 times. That's it. So that's the show. All right, we'll see you all, what is today? Saturday. Okay, so Monday, got the TA call, Trans-Ambassador call, so we'll probably be going over on Equity Monday, Maxim Monday. So see you all then. Good night all.